Good afternoon. I am Jim Burnley, a partner at Venable. Thank you very much for joining us today. I am joined by my fellow partner at Venable, Ariel, who leads our autonomous vehicle practice. Ariel served at DOT in the first Trump administration as counselor to the deputy secretary. I was general counsel, deputy secretary, and ultimately secretary of transportation in the Reagan administration. We are going to jump right into this. If we can have the first slide, please. I think it's important that we begin by emphasizing the framework within which the Department of Transportation and its various arms are looking at the regulatory issues and what their responsibilities are vis-a-vis the Trump administration's overall regulatory agenda. And it's important to, I think, to emphasize that because sometimes we get so focused on a particular rulemaking or the rulemakings of a particular modal administration at DOT, you can lose sight of the fact that they are operating within some pretty clear directions and constraints from the White House. Those, as you probably know, are implemented day to day by an arm of the Office of Management and Budget, the Office of Information and Regulatory Affairs, OIRA. So let's just run through real quickly at the beginning what that basic framework looks like. You can see the two executive orders referenced there that were issued right at the beginning of the administration. And it's important, I think, to really highlight that next bullet, which is that agencies are required to identify 10 existing regulatory burdens to be revoked for each new significant regulation. That is being taken seriously by every indication in the administration. That was not just exhortatory, it is a directive that the various agencies government-wide are expected to implement. One other area that applies to not just the Federal Highway Administration, but also the Federal Transit Administration, to the Maritime Administration, to the FAA, in varying degrees to other administrations, is what is known loosely as Buy America. Covers a lot of territory, but I suffice it to say that those regulations have been tightened by the Trump administration, particularly including the termination of Federal Highway's general waiver for manufactured products, and that applies specifically to steel and some other metal products. The regulations that had been on the books for many years on Buy America at FHWA have been taken very seriously by basically every administration in the modern era. But that said, they've gotten even tighter, and I expect that tightening not only will continue, but may even increase somewhat. Next slide, please. Moving from the administration-wide directives to what Secretary Duffy early this year laid out, you will see here reference to a DOT order that was issued in early March. As the slide says, it's 23 pages long. I recommend it to you because it sets out the basic framework within which DOT is attempting to implement the administration's agenda. First and foremost, rules are supposed to be technologically neutral. In other words, DOT does not wish to be in the business of dictating particular technical answers to various issues. that means, in effect, you set performance objectives rather than trying to be prescriptive in what kind of technology is used to meet the regulatory requirements. Regulatory burdens are supposed to be minimized, and I think, as the third bullet says, the second part of it, it's particularly important to emphasize that DOT intends to do everything it can consistent with safety to reduce market entry barriers. Benefits are to exceed cost unless law or safety requires otherwise. That requirement has been around for many years. It has waxed and waned in terms of implementation. But I believe that Secretary Duffy and his team also mean for that to be taken seriously. And then, as the last bullet says, he created with this order a regulatory reform task force to oversee regulations department-wide. And that task force has been put in place. And I can't speak to what it's doing day to day, but if you're thinking about regulatory issues at DOT, I think it's useful to keep that in mind. Next slide, please. Within the administration-wide directives, I think it's important to note in particular the NEPA and environmental policy reforms that have been implemented throughout the Trump administration. And on June 30th, DOT did issue a department-wide set of instructions on NEPA reforms. As anyone who's spent any time on NEPA issues at DOT knows, they can be very, very frustrating. The requirements have been quite elastic over the last several decades and can often lead to what seem to be endless and prohibitively expensive exercises trying to meet the NEPA requirements. So the department has set some hard deadlines. They have attempted to simplify the categorical exclusions, in other words, to limit the subject matter. They have even gone so far as to set page limits. And of course, the question will be going forward, how seriously those are enforced. My personal hope would be that they would be taken very seriously and they will be enforced. And then the other significant part of these directives is narrowing the definition of what are called federal actions. I anticipate that, as we have seen before, we will continue to see litigation that may have an impact in the next few years on how that definition of federal actions ultimately is defined, what the parameters are. But again, Secretary Duffy and his team intend for the NEPA process to be much more streamlined, much less expensive, much more predictable than it has been in the past. And interestingly, you probably heard about this, but it's important, I think, to take note of a Supreme Court decision that came out very near the end of the spring term in mid-June, the 7-county infrastructure coalition versus Eagle County case. And I will tell you, perhaps immodestly on behalf of the firm, that Venable represented the 7-county infrastructure coalition in that case and was successful in getting the Supreme Court to rule in its favor. And that decision, as you may know, further constrains the NEPA process in defining with a fair amount of specificity how broad a look you have to do under NEPA. In the facts of this case, oil that was being moved by rail from Utah had triggered a requirement that the NEPA process take into account impacts it might have as far away as New Orleans. And the Supreme Court said no to that. That did not make any sense on any level, and it was not necessary. And in fact, has given us pretty specific guidance going forward about what the parameters will look like. Next slide, please. In terms of basic policy shifts, there's been a lot of press about this, and so no need to spend a lot of time on it. But I think, again, in talking about what matters in this second Trump term at DOT on the regulatory side of the House, it is important to note that early on, Secretary Duffy announced that they will not be enforcing anything in the DEI categories or what he and others in the administration have called the green use scam provisions that had been included by the Biden administration in various grant agreements, unless those provisions are required by either a statute or an existing regulation. So, in other words, that to some extent has to be looked at on a case-by-case basis. But again, the broad overlay is that Duffy is attempting to get the department to pull back from telling grantees that there are very specific requirements that fall into either of those categories. With that, I'd like to turn it over to Ariel and let Ariel help us understand what's going on at NHTSA and the Federal Motor Carrier Safety Administration and his area of particular interest.
Fantastic. Thanks, Jim. And just share, it's a great honor to be able to work alongside you and your tremendous experience with the department and working on all of these issues over the years. There's certainly a lot going on in the transportation space, not just new technology, but as you've laid out, a number of new developments, or maybe some not so new, as they say, nothing new under the sun in Ecclesiastes. But we certainly see some of these cost efficiency measures and deregulatory efforts come and go as the years go by. So I think I want at the outset just kind of say, as noted, I'll be focusing the next bit of time on FMCSA, the Federal Motor Carrier Safety Administration, and NHTSA, the National Highway Traffic Safety Administration, and how some of this has been applied. Of course, FMCSA is responsible for regulating commercial motor vehicles and carriers, and NHTSA oversees vehicle safety and fuel economy standards. Now, just a quick recap, just so we can set the table as the Secretary laid out. The executive orders and the DOT order very much are going to be put into practice here and have been put into practice. The EO 14192 and 14219 has been mentioned, 10-1 for each new significant regulation. So we're going to see how this kind of plays out. The internal DOT rulemaking directive, that was something in the first Trump administration, the Trump 45. I think internally or maybe externally, we called it the rule on rules. There was, of course, guidance on guidance as well. But the rule on rules, the internal rulemaking directive, reinforces the need to, as was noted earlier, minimize the market entry barriers, promote technological neutrality, and to ensure that the benefits exceed the costs. Unless, overridden by statute or some compelling safety need, which of course is always present. So it's created this policy environment where these agencies are expected not just to pause or slow down new regulations, but to actively reform, streamline, or rescind these legacy rules. So let's dive into that a little bit more. So if you could go to slide 7. So FMCSA deregulatory activity. And I would just say, I know it's part of the name of the webinar too, deregulation. I think it's a helpful term because it gives a thrust of what's being done here. But there's also, I think, streamlining, updating is another important word that comes up here. So I just want to flag that not everything, it's not so much that the word deregulation is a good word or a bad word. It's a neutral term, of course, but it does, I think, have a bit of an umbrella effect to it, where there's other concepts that go into that. Like I said, updating, is that deregulatory? I don't know. You can debate that, but I just think that it's important to set that up. So as we get into it, the January 20th regulatory freeze did lead to a review. And then on May 29th, let's talk about this deregulatory package. There were 20 actions in total, 2 final rules and 18 notice of proposed rulemakings. The final rules, you see, it did eliminate some obsolete routing regulations that were no longer in active use. I think this one went back to the Interstate Commerce Commission, and that's something related to 1952, which makes my eyes glaze over a bit. But I would just say that that's more of the something that's streamlining and updating. There is a removal of outdated civil penalty references to drug and alcohol enforcement. Again, some of this is real just kind of legal regulatory cleanup, so that we're, query how much ambiguity was actually in the marketplace in this space related to these kinds of mixed references and things like that. Maybe there were some, but it is important and helpful for the agency to go back and clear out what I have sometimes called, the regulatory underbrush. You gotta clear it out and make it make more sense. The NPRMs that were put forward, as noted here, proposed a few things, eliminating the requirement for drivers to carry a printed ELD operator manual and understand the importance or the significance of trying to move ahead technologically. Duplicative requirements for rear impact guard labeling, retroflective sheeting. There was relief from self-reporting CDL violations these are already captured electronically, so it didn't make a ton of sense to continue to have this on the books. There was exemptions for military technician drivers, something that's been around. That concept, of course, it makes good sense, and I recall some congressional hearings on this, and something that's been present for some time. And then interesting one, because there is a focus on this technologically, at least in the autonomous space, we'll get to in a little bit, repealing long-standing, but what were described as irrelevant rules related to spare fuses, flares, and obsolete modal references to like water carriers, things like that. So some of that is interesting because there's been some exemption petition activity around what's left there, which is warning triangles that have to get placed behind a truck when it's disabled or on the side of the road. But that being said, this was put forward as to clear things out. So as we go to the next slide, it is my duty to inform everyone the CLE credit that is here in the webinar, waiting for CLE credit, to please use the following CLE code. It is Transportation 2025, no space. And I don't think it's cap sensitive, or case sensitive, I should say. Transportation 2025. Okay, slide 8. So moving on some of the FMCSA deregulatory activity. So it's not just about repealing rules or updating rules, but there's some pilot programs that are in place to test data-driven flexibility. And 2 of the ones that are initiatives that are underway, one is a sleeper berth flexibility pilot that allows drivers to split their 10-hour off-duty period into 6 and 4 or 5 and 5 segments. And it's described as providing a more realistic set of options than the 8-2 split. Another pilot is a split duty pilot. It's about testing whether drivers can pause the 14-hour duty clock for multi-hour breaks, and can let them, the idea is to let them wait out traffic or rest without losing productive time. So these are 2 pilots that have been put forward. The agency is also working on modernizing the digital registration system, consolidating FMCSA and DOT number processes into a streamlined portal. Related to these efforts, that's I guess not reflected in the slide here, is the announcement on June 27th of a pro trucker package that was put out by DOT. It's a department-wide initiative. I know we're talking FMCSA, but it's department-wide. And it was launched under President Trump's April executive order, focused on the working conditions of truck drivers. So this includes things like updated truck parking guidance. It's intended to give states more flexibility and access to funding, commitments to streamline roadside enforcement, cutting down on duplicative paperwork and inspection burdens. There's an expansion of hours of service pilot programs, just as I just noted earlier, a revamped crash preventability determination program to ensure drivers are not penalized for accidents outside of their control. And there's a task force to evaluate driver retention and small fleet incentives. So that's what's described as a pro truck driver package, quote unquote, that was put out on June 27th. And I think it does, well, it was put out as, emanating from the executive order related to working conditions of truck drivers. I think it does also come as part of this overall approach to deregulatory approach that is informed by, if not directed by, the orders, the dereg orders that the secretary noted, as well as the internal DOT rule. Let's go to the next slide. Then we're talking about NHTSA, some of the deregulatory activity. I think similar vein, a lot of clearing out some of the regulatory underbrush participated. The agency participated in the same May 29th deregulatory initiative with 16 actions in total. It's included 12 NPRMs, looking at some outdated FMVSS, Federal Motor Vehicle Safety Standards. As you see here, we're eliminating a glazing standard for vehicle types that haven't existed since 2006, restructuring roof crush standards to reflect modern vehicle architectures. There was a couple of others in 210 and 204. That again, it really ends up being a kind of a technical clarification. These are not, deleting FMVSS. These are updating standards to reflect where we are, which is 2025, and the vehicle technology that we have, and trying to remove any, if as much as possible, any kind of uncertainty or ambiguity from a legal perspective, as long as this language still existed. So there were some additional cleanups proposed, as you see, across a number of other standards. And then other dereg actions that have been put forward have included NPRMs. One would be to withdraw the 2015 FMVSS 218 on motorcycle helmet design. And then another one, modernizing NHTSA's technical rulemaking procedures to speed up feature updates. And that would sort of get at more of a guidance or, a rule on rules internal to NHTSA that would help speed things up. We know sometimes can be a bit of an issue, and we want to see things move a little bit more quickly over, not just in NHTSA, not picking on NHTSA or any particular group there, but really about trying to find ways to move more quickly in the modern era. All right, next slide, please. Everyone's favorite topic, corporate average fuel economy. And so here's one where certainly, Jim, if you have thoughts here, feel free to jump in, but I'll just give kind of the picture. The high profile action that has been taken has involved these fuel economy standards. So first in May, the agency finalized a rule to roll back inflation adjusted CAFE penalties. I believe they were restoring the rate to $5.50 per 0.1 mpg shortfall, rather than the $14 level reinstated under the prior administration. So the continued ping pong, seesaw, whatever analogy you want to use for whiplash, continued there, at least with respect to regulatory action. But what did change was then the rollback was really overtaken by statute on July 4th, as some of you may have noticed. Congress passed or enacted, I guess I should say the president signed, I think on July 4th, the reconciliation bill. One big beautiful bill is its name, and that included a provision to set CAFE penalties for light duty vehicles to zero. So what that did is it effectively eliminated the financial consequences for failing to meet fuel economy targets. And so That's significant. It's my understanding there is no sunset to that provision. So that really does change the game. In a sense, as someone who worked there, and Secretary, you can weigh in too on this. It's almost mercifully the idea that you move into a new administration, and it's just the immediate work gets underway to just move back the same thing. The fact that their Congress has spoken on this, however one feels about it, does sort of give a reprieve, at least to the staff over at the agency, if not anything else. But I don't want to weigh in normatively here. I'm just saying it's nice to have an actual change here.
Well, let me ask you one question about that, Ariel, and let me say to those who are watching, please post questions if you have any. We encourage them. But if I were an automobile manufacturer, and knowing that 3.5 years from now, roughly, we'll be in the midst of a presidential campaign in 2028, and given the sort of balance of power between the two parties nationally, the pendulum swings, but it doesn't swing in a predictable way, particularly this far out. I wonder, how I should think about this. Should I assume that cafe standards are basically dead permanently, since the penalties are no longer available for enforcement purposes? Do I worry about something that could happen in a new administration, a Democratic administration, with much more sympathy for pushing fuel efficiency over at EPA, which has gotten very aggressive in the Biden years, particularly in its role here? When my era at DOT, we didn't pay a lot of attention to EPA on this or any other issue. But that's certainly dramatically changed. So how comfortable, if I'm an automobile manufacturer, can I be about this particular scenario?
It's a great question, and I think a big part of it is to start with the fundamental notion that the program wasn't eliminated, just the penalties were reduced to zero. And so it exists. To your point, there's political volatility. It would have to be changed in some subsequent instrument. And here's getting a little bit over my skis, I would say. But you can envision a situation where the political pendulum swings, and restoring those penalties is in theory, a revenue raiser. So it actually, there's maybe some juice to put it back in. So that's an issue. You raise the EPA, which sort of complicates the picture more. And there's still, I think, a good amount of uncertainty how the state-based programs are going to proceed, at least to a certain extent. And so I think all that kind of puts it in a place where I don't envy the folks who are making these decisions at OEMs, but at least for the interim, they can not feel what some describe, as a great amount of pressure, sort of Damocles kinds of things hanging over. But they probably will continue to invest in technology that increases the efficiency. That would be my thought on that. There's probably many others, maybe on this in this webinar, but certainly others in town here that have strong opinions on all of this, and it'll be up for discussion for sure. So,
Thanks.
so just kind of thinking through a little bit more on this is, as noted, NHTSA does still retain oversight of reporting and compliance submissions. And maybe that's another kind of aspect, as I said at the outset of the answer, still to report and comply with submissions, but they just can't impose monetary penalties for violations. So another consequence of that is the cafe credit trading market really is no longer, it's collapsed. And that has a significant impact on electric vehicle manufacturers who depended on those sales for revenue. That's another sort of economic consequence, not just for the OEMs that aren't paying penalties, but for the credit trading piece. It's something to keep an eye on. NHTSA also issued a new NPRM on crash test modernization. I think that one was focused on updating the dummy specifications for child restraint side impact testing and improving, intention is to improve safety while simplifying compliance burdens for manufacturers. So next slide. Now let's talk about autonomous vehicle policy developments. So here, we work on this as we do with the other topics, but here really day in, day out from a compliance and public policy perspective. This is at the bleeding edge of where motor vehicle policy and law and regulatory regulations are going. And there are a lot of instances where it's not a clear answer. It's not a question of comply with this existing FMVSS or not. So there's a lot of work that has been promised to be done and needs to be done in order to give clarity, certainty to not just the industry, the autonomous vehicle industry itself, but to other stakeholders, including state governments, state DOTs, including other types of entities that are really important in this space. So in April of 2025, the Secretary and US DOT announced the new AV framework. For those of you who have been involved in this issue for some time, there have been a lot of frameworks, a lot of announcements, a lot of guidance documents, things like that. So what I think is important with this just very clear simplicity. 3 pillars. You got to ensure safety via modernizing the FMVSS. That's an important complete phrase. You got to modernize the FMVSS, otherwise there's sort of these ambiguities. But safety, of course, is paramount. Encourage innovation through clearer exemption pathways. So very quick background on this, some of you may recall, right? In the early days of AVs, let's call it 2015, 2016, 2017, a big effort was to be able to apply to NHTSA, a company that's designing a brand new vehicle. If it's autonomous, it's fully autonomous, level 4, let's say, if you're familiar with those levels, then it's performing all aspects of the driving task through the automated driving system. Why then would the vehicle need a steering wheel, need a brake pedal, and those kinds of questions? But it turns out it does need to have those features because of the regulations. The NHTSA regulations require the Federal Motor Vehicle Safety Standards. So the ability to apply for an exemption from those was a process that really had, in a sense, broken down, took too long, no clear understanding of what you needed to submit. So a commitment from this administration to clarify, update, modernize the exemption pathways, and then reducing the administrative delay for deployment readiness is related to a lot of that, but really looking to get to deployment as an actual clear focused goal of the department. Frankly, in contrast to, there's been 15 years or longer of research and testing. And now that we see deployments in place, for those of you who've been in San Francisco, been in Phoenix, been in Austin recently, focusing on deployment readiness of the department and seeing that as a clear goal. So that was the framing of the framework. The next piece would be this Part 555 exemption process. As a note of the exemptions, I laid it out. That's a commitment that they made to streamline these reviews of FMVSS exemptions for vehicles lacking these conventional controls. So that's Part 555. Other kinds of exemptions that NHTSA has authority to engage in would be for research and demonstration purposes. And there was a just historical quirk of the way the regulations worked, where you could actually get some authority to bring in so-called non-compliant vehicles that didn't otherwise comply with FMVSS. Maybe it's a new concept vehicle for autonomy, but you can only do that, or the easiest way or best way, or really the only way to do it would be to actually import it. What's called the Box 7 process for importation. And so that rather than domestically produced vehicles, it did not have access to a similar kind of exception or exemption. So the commitment is to fix that on the part of the administration early on. This is all happening again within the first 6 months of the administration. That's a positive thing from the autonomous vehicle side. There are some clarifications on federal state preemption, announcements related to the federal government's role in vehicle design and performance regulation. I'll just say this is tremendously important to focus on. There is a role for both federal and state oversight and regulation of motor vehicles. Everyone agrees with that. I mean, everyone I've ever talked to, including the AV industry, including all the stakeholders. The states regulate vehicle operation, rules of the road, traffic, licensing, insurance, and so forth. But what has gotten lost a little bit in the autonomous vehicle context, as the federal government has not moved at a quick enough pace, is that the federal government regulates the design, construction, and performance of motor vehicles. And the states, I think, in the absence of some clearer federal guidance, have started to tiptoe into that area, in some cases move very aggressively into that area. And this administration and moving forward with the statement they need to get working on this is very important. It'll depend on what we see happen as part of it. We're going to be looking closely at that, I think, as everyone should. And then finally, there was a standing general order, some of you may recall or know about, in 2021, issued that called for the collection of data from not just autonomous vehicle companies, but all motor vehicle companies and suppliers that were involved in advanced driver assistance as well. So level 2, level 3, level 4 type autonomy. It was, I think, at the time it was put out, probably an imperfect instrument, imperfect in its in the way it was done, maybe in the substance as well. Having to update the party lists to a standing general order. There were companies that were entering this space that weren't on the list and not reporting. There were duplicative reporting requirements and things like that. So I think in that respect, there's going to be, it looks like, some kind of update to this, and I think it's been put forward, and that's significant. Again, just some items that have happened in the early instance. So with that, let me pause there. I see there is a question. Is that Jim? Is that what you want to mention?
Yeah, it's for you. So.
Okay. So let's take a look at it. We'll see. Can you talk about the AV step rule submitted in January as an NPRM by the Biden administration? How do you think this? Okay, so good question. So for a good chunk of the Biden administration, there was talk of an AV step rule, and what that it is referring to is an acronym that the administration had for a national pilot program for autonomous vehicles. That was the acronym that was, forget what it stands for. I had too many acronyms in this town. But the concept actually originates back in 2018 in the first Trump administration, when they had what they called an AV pilot program. So in a sense, there's good continuity in this front from administration to administration to have some kind of national pilot program. And the question is a good one because it references given changes to Part 555 and Part 591 exemptions. So how do those things go together? So I'll just say this. I think there is a role, well, it doesn't matter what I think. It's my understanding that NHTSA and officials continue to see some value in looking at those things, those two programs distinctly. So by that, I mean Part 555 exemptions. Talked about that process to apply to NHTSA, be able to have vehicles that do not otherwise comply with the FMVSS. It doesn't have a steering wheel. Just keep using that example. Part 555 process lets you have a vehicle without a steering wheel, and you can use it for whatever purpose you want. You can sell it. You can put it on you can commercialize. You can do whatever you want with it. It's treated exactly like another car. It's just exempt from certain things. Call it a full exemption. And the problem that has always been identified there is by law, by statute, NHTSA can only grant 2,500 such exemptions per vehicle for a maximum of 2 years. And so that there's a statutory cap, cannot be exceeded. That being said, the process was so difficult to even obtain those exemptions that that's what's being reformed. The 591 piece is really about NHTSA's authority to do research and demonstration, and that does not have caps. So the question there is, in a national pilot program under NHTSA's authority in that respect, what are the outer boundaries of such a program? And that's where, I think AV STEP was a previous administration's effort. There's a new administration. They're going to have their thoughts on how to exercise pilot program, NHTSA authority to invite vehicle manufacturers and autonomous vehicle developers into such a program under certain parameters, and what those parameters are will be the whole of it. And then finally, the question is the trade-off. You're invited into such a program and participated in it as an AV developer, under whatever conditions, does that give some kind of preemption for many of the state laws that keep popping up and either get enacted or just under threat of enactment is enough to have a chilling effect. So does it have a preemptive effect or not is kind of one of these key questions. So Congress will certainly have something to say about all of this. They have expressed, a number of stakeholders there have expressed great enthusiasm and excitement over advancing AV legislation in a new form this term. So we'll have to see how that shakes out, which could clarify a number of these things. All right. With that, I'm going to turn it back to Secretary Burnley.
And I'm going to ask you two more questions before I move on. One, I know that there have been some experiments with AV trucking, I think particularly in Texas. Can you update us on what is occurring in the trucking industry and what you expect will occur going forward the next 3.5 years?
Sure. Great question. Appreciate it. So Texas has become the epicenter of the autonomous trucking industry. So it's a very exciting and interesting kind of development. The big picture, we have a significant labor shortage, truck driver shortage in this country, 80,000 drivers and growing, well documented, and it's going to continue to increase and create. And the more of a shortage and the more sustained, the more it contributes to inflation as the cost of goods goes up. When you can't find drivers, you have to pay existing drivers more and more and more, or find other solutions. So autonomous trucking has really stepped forward into that environment and finding good success, not just technologically, which is, we've seen a lot of really great testing and outcomes there, but also starting to haul freight in Texas, in between, the triangle there, but also in I-10. Some of that is due to some good state laws that have been enacted, excuse me, across I-10. So it's a really good story. It, what you end up seeing is the kinds of jobs and hub-to-hub technicians, advanced technology jobs, even people with CDLs and drivers getting involved in more local routes and things like that. I mean, this is a very exciting development, in addition to, of course, the context of us trying to win a global race for this technology, and not just with friends, but also adversaries. So Texas is a great story there. There are some regulatory challenges there that specific to AV trucking, that continue to need to be worked on and focused on. As I noted at the outset of my time here, one of those is related to warning beacons and the requirement to put out warning triangles for these trucks. And when you don't have a driver, it's a bit difficult. So there's petitions submitted, and that continues to be worked on.
My other question is broader, and I'm not passing judgment by asking the question. That just, I think, is probably a consensus view of NHTSA that throughout its history, it has been known to emphasize safety for the regulation of motor vehicles, how they're built, leaving the regulation of operation to the states. But in recognizing technological developments, not just AV, but others, and showing any flexibility with regard to rules that might arguably inhibit technical developments, even those that are thought to be pro-safety. NHTSA has not been known for moving with rapidity, whether it be on a full-fledged rulemaking or even a waiver request. I personally had the experience a few years ago with a waiver request where the arguments were pretty much one way, that the waiver would be pro-safety, and yet it took NHTSA nearly 2 years to address the issue. So in the regulatory environment of this second Trump administration, do you see any signals one way or the other about how NHTSA will proceed in looking at requests for rulemakings or, as I said before, even waivers on a limited basis?
I think it's a good, great question. Some of that remains to be seen, and it's not a punt on my part. I think it's fair to give them a chance to staff up fully to really understand to what extent that there could be a change in dynamic. I mean, it's the first, as you know, probably better than anyone, but some of us have been involved also in the administration. That first, few months is just such a burst. It's hard to know whether, as they settle into kind of a more of a pattern of activity, does it mean that they're going to process exemptions more quickly or move more expeditiously on rulemakings? Tomorrow, as you and I were talking earlier today, tomorrow, of course, there's the hearing that's going to be for a full administrator for NHTSA, for FMCSA, and for the Pipeline and Hazardous Materials Safety Administration, PHMSA. Their hearings tomorrow, a week from tomorrow, as just noticed. There'll be other nominees that are very important for the department. Getting those folks in place helps with bandwidth concerns and helps with setting policy, as you know. So I think the signals seem positive on the front you're describing, but at the same time, there's always going to remain a focus, for example, and it's on safety. So the idea that grab an idea and move forward with rulemaking will never happen. It'll be grounded in the research and the safety, and that's what we want.
Right.
There certainly has been some delay that seems not fully tethered to strict safety concerns, and trying to figure out where that is and how that happens, how it can be reduced or eliminated, I think is a goal of the administration, but whether they execute on it remains to be seen.
Thank you for that. And I will take the handoff and we need to move to the next slide. The last few minutes we've got, I thought it'd be useful to simply highlight a handful of regulatory initiatives that are already apparent at DOT. These are not exhaustive. As Ariel just alluded to, the administration is still in the process of getting a number, I think the majority of its modal administrators confirmed and in place. And that alone can, getting through that process can accelerate what occurs in terms of implementing both the administration's and Secretary Duffy's initiatives, regardless of what part of the department you're in. So these are simply examples of rulemakings that do seem to be either already underway in the first few months of this Trump second term, or have been signaled. And first and foremost, I wanted to touch upon the unmanned aerial vehicles area, the drones, as we refer to them. The first of the initiatives they have already taken in this area with a proposed new rule will allow use of drones beyond line of sight. In other words, drones over the horizon, beyond what the operator can see. Today, and for quite a few years actually, the FAA has occasionally let experiments occur on a quite limited basis in the operation of drones beyond line of sight using the waiver process. But at least among the drone industry, and certainly among many drone users, there's been a lot of frustration at the FAA's hesitancy in this area. And so I think the probably is widespread support in that community for the proposed rule that will allow beyond line of sight activities. And just to come back to the department's most fundamental mission, which is enhancing transportation safety. You think about inspecting roads, inspecting railroad tracks. The use of drones can be very helpful. It may not be the only mechanism you would depend upon for inspecting surface transportation to make sure it's safe, but it can be very useful in identifying problems, at least so you can then send people to further analyze them. The other rule that I've noted that they have proposed already in the last few months is intended to restrict the unauthorized use of drones. In other words, to tighten up on what is actually occurring in the real world over mass gatherings like sports arenas. And there have been quite a few instances of drones operating, almost always, I think, without anybody thinking they had sinister intent. But nonetheless, the drone's up there. You don't know who owns it. You don't know what its operator's intended use of it is, beyond just having a bird's eye view of events below. And it does create, understandably, very serious safety concerns. So the department is moving, I think, with some intention to get it done sooner rather than later, to put explicit restrictions in place on the use of drones in those kinds of settings. And then PHMSA, part of the department that doesn't get a lot of front page attention, but which has a vital role in regulating the safety of any pipelines that carry petroleum products, LNG, oil, gasoline, you name it. PHMSA has also already started the rulemaking process to update both LNG pipeline regulations and the rules on transporting anything that's petroleum based. And certainly as the Trump administration is doing all it can to open up exploration for oil products and expanding the availability of them, PHMSA is going to have a vital role in making sure that they can be transported safely. Then the last slide touches upon the Federal Highway Administration rescinding the greenhouse gas rules that the Biden administration had put out that first and foremost required states and metropolitan planning organizations to set declining CO2 targets and then required certain actions to meet those targets. And I'm sure for those public entities that are subject to such rules, there's a bit of whiplash at the moment. And it does inevitably mean that planning gets disrupted or delayed. But it's in the nature of our political system, as we all know, that you're going to see these kinds of changes when you have a change in the party of the administration, at least in this era. So with that, I'd like to wrap us up. First and foremost, thank you for those of you who stuck it out with Ariel, with me. If you have additional questions that occur to you, we welcome them. You can reach out to us. Our email addresses are on the Venable.com website, or you can call us up. Our phone numbers are there. We'd be delighted to continue the conversation if we can be helpful to you. And it is my responsibility as we wrap up also to repeat the code word for the CLE credit, which is transportation 2025, and that's with no space between the word transportation and 2025. With that, Ariel, do you have any final thoughts or wisdom for this assemblage?
No, just stay tuned to further developments in all of this. I think it's going to, that and surface transportation reauth will be make it for an exciting year.
Okay, great. Thanks very much. And thanks to those at Venable who've supported us in putting this together this afternoon.
Thanks.